was no pre-sentence report or adjournment. I was sentenced on that day and sent to prison on that day. And nobody knew who was going to go and pick my daughter up from school.
Her father rang me to say she's just been sentenced to 4 years, and that's the last thing I thought was going to happen. You know, the enormity hit me when I thought, oh, I've got to look after my granddaughter.
Because there will be cases where there is an alternative to a custodial sentence. If they had a suspended sentence, they would still be able to care for their children, thus, minimising the harm that would be done to their children.
Every year, thousands of children are affected when their mothers go to prison. Many of the mothers who go to prison are their child's sole or primary carer. If you have a child who is dependent on you and you are facing sentencing in a criminal court, there are some important things to remember in order to safeguard your child. The law and sentencing guidelines mean a court has to consider the impact on a child who will be left behind when a parent is sentenced to imprisonment.
Within the sentencing process, there is a formal place for both children or dependents to be considered when a sentencer is actually considering, firstly, the type of sentence to impose, and secondly, the nature or duration of that sentence. That derives in part from statute and international provision as well.
You've got to have regard to the case of Petherick, which was a decision that came out of the Court of Appeal in 2012. Which said that clearly where a case involved children that may be parted from their single parent, the favour had to be in favour of the child, and that the parent shouldn't receive a custodial sentence or an immediate custodial sentence.
The cases of Petherick, Mills, Bishop and Arnold, and the overarching principles general guideline, have set out the way in which courts should consider children. Sentencers are required to balance the impacts of a parent's sentence on their children against other sentencing factors.
It's embedded within the definitive guideline as one of the typical mitigating factors as to whether an individual is either a primary carer or a carer of some type and has some level of dependence upon them.
Your legal representative should tell the court about your children. Judges and magistrates have to consider the impact on a child when sentencing their parent, but they can only do this if they know about your child. It's important that you tell your lawyers and probation about your child, and they should then tell the court, and the court has to listen. If you are pregnant, you should let your lawyers and probation know, as this is also a factor that should be considered in sentencing.
My advice to anyone who is possibly facing a sentence or who is on remand right now is to not just assume that the professionals around you are aware about your children's situation, and to let them know that about your children, and to inquire who is going to be looking after them. That should be the priority, and you should make sure that your representation knows about that, and that as many services are involved as possible early on.
Seek support from probation, even if they're not yet involved, because at some point they will be involved, and to make that first move yourself and let them know of what you're going through, and that you do have a child, and that you need help and advice of what to do, and childcare issues and safeguarding issues around who's going to care for your child if you should go to prison.
Ask for a full pre-sentence report for safeguarding reasons. The general guideline, overarching principles, states that the court should always ask for a report when a parent is being sentenced. Your legal representatives can provide the information to the court in several ways, but the best way is through a pre-sentence report. In that report, probation can inform the court about your circumstances, your responsibilities for your child, and the safeguarding issues for that child if you are sent to prison. Ask your lawyer to ask the court to adjourn the sentencing hearing for some time so that you can tell probation about your child. Adjournments can be for a few weeks, and this will give you time to make arrangements for your child in case you are sent to prison. Don't assume that your legal representative has information about your personal circumstances and your child. You need to be prepared to tell them about him or her. It's not always easy to speak to strangers about such personal things, but it is important to do it for your child's sake.
The court's position is this, that if it doesn't have the information, it can't do justice to a case. So it's vitally important that you lay every factor out. Look at whether a child has any disabilities. Look at whether they've had any psychiatric intervention. Look at whether social services have been involved. Is the child going to be separated from their siblings? Is the child going to be moved school? All of those factors are important factors that I think any sentencing judge would want to know about before making that harsh decision about imposing a custodial sentence.
These are the kind of things the court needs to know. Do you have children or are you pregnant? Who will take care of your child if you are imprisoned? Has this person been asked about taking on the care of your child? Do they have space in their home? If you have more than one child, will they take all the children or will they be separated? Do they have the means to support your child? Are they in good health? Will they have to give up their job if they take on your child's care? Do the rest of their family, partner and children also agree to taking in the child? Will your child continue at their current school or nursery, or will they have to change school? Are there school places in the area they are moving to? Is your child at a crucial stage taking exams, such as GCSEs? Does your child have particular health or emotional needs? Will the alternative carer be able to cope with those needs? Will your child be able to visit you in prison, bearing in mind it may be far from where they are living? There are 3 important things to remember if you are a parent and you're going to be sentenced in court. Firstly, the judge or magistrate has to consider the impact on a child who will be left behind if his or her parent is sentenced to imprisonment. The law and the legal guidelines are very clear about this. Secondly, your legal representative should tell the court about your child so that the court is aware of him or her and can take their interests into account when you are sentenced. And finally, you should ask your barrister or solicitor to ask the court for a full pre-sentence report so that this is done to ensure that your child is safeguarded. Here is some advice on how to talk to the court about these issues. This will help you if you're representing yourself, or if you're represented by a lawyer, you could ask them to watch this film.
In my experience, the very first thing to do is ensure that everything that you have to say is evidenced properly, so that there's a very focused approach looking at what the impact will be in this particular case on this particular dependent and what it entails for that particular dependent, putting it all out properly. So that when it comes to sentencing, a sentencing judge has to grapple with those issues and has to make determinations on those issues and deal with them adequately.
Don't be afraid to be forceful with the sentencing court. Be polite, but be forceful. Say, well, I am going to trouble you, Your Honour, or Judge. I am going to go through matters that may be applicable to this particular family and to this child. Don't be afraid to do that. Take the time to walk them through the authorities. If they choose at the end of it not to listen, that may be a problem that they will have to face in due course if the matter goes to appeal. But always remember that authority of Petherick from 2012, which clearly states you favour non-custodial disposals where a matter is on the cusp. Always make sure that you give that sentencing tribunal something to think about.